a conversation I frequently have with either potential new clients or existing clients is what happens at a preliminary conference, which is early in a litigated divorce action. My name's Ken Novenstern from Fredman Baken Novenstern, LLP, and the preliminary conference can be a very effective way to proceed for a number of reasons. I had a call from a prospective new client this afternoon, and he was expressing frustration. He had been in a process where he thought that he and his wife had negotiated an agreement, and they went through this for about a year. And when his attorney was raising the possibility of getting the agreement signed, he found out that they didn't have an agreement, and now he's in the position of deciding whether to commence a divorce action. And so I talked to him about a way that he could potentially use a divorce action and a preliminary conference as a catalyst to have another discussion about the terms of this agreement. So what is a preliminary conference? Once a divorce action has been started, then the parties often continue to discuss and negotiate and exchange financial information. And at that point, there's no judge involved. Once you file something in New York called a request for judicial intervention, then you can get a preliminary conference with the court. And in Westchester, once that form is filed after the commencement of the action, you can actually get in before a judge within 2 to 4 weeks. So it's a pretty prompt process. And in regard to preliminary conferences, they date back, I believe, changes in the court rules back in the late 1980s, certainly 1993. And part of the purpose of these preliminary conferences is to get people in front of judges. When I started practicing in Syracuse in the mid-1980s, oftentimes we would go into court appearances, the attorneys would go back into chambers, we would talk to the judge, and the parties never really knew what was going on. So with the preliminary conference rules, the parties actually have to be present in front of the judge, and they can see what's going on, which is very important. And so when you get into a preliminary conference, just a quick outline, the purpose of the conference is to provide a schedule for the case, educate the judge as to the issues in the case, what's resolved, what's not resolved, to have an attorney appointed for the children if necessary, have an appraiser appointed for the house if necessary, and to lay a framework for moving the case forward. Typically, once the preliminary conference stipulation is filled out and the judge signs it so that it becomes a court order, that's the foundation for the case going forward. And it will also provide for a date, usually within 2 months, to get back into court. It also provides for the completion of discovery. So it's a very important step, and it can be used as a way of addressing outstanding issues, such as the prospective new client that called me, to see if the judge can help get a settlement that's already substantially together over the goal line. And so many reasons for a preliminary conference. I could say much more about it, but that would make for a very long video. So if you have questions, if you want to know more about preliminary conferences, please reach out to me at 914-997-9070. Ken Novenstern, Fredman Baken Novenstern. Take care.